This is a brief amendment to Section 201 of the Social Welfare Consolidation Act 2005. I want to amend it. It says the executive or deciding order may, in any case where the executive deciding order considers it reasonable, having regard to all the circumstances of the case, so to do, determine or decide that supplementary welfare allowance shall be paid to a person by way of a single payment to meet an exceptional need. I want to add the words Cathaoirleach and Minister, an exceptional need which is not necessarily unforeseen. Now, Minister, in 2017, I think you told me, or would it have been or your predecessor? You told me that under the Supplementary Welfare Allowance Scheme, the Department may make a single exceptional needs payment, an EMP, to meet essential once-off and unforeseen expenditure, which a person couldn't be reasonably expected to meet out of their weekly income. And you told me, of course, for 2017 that the scheme was demand-led and was costing 32 million. But I've had a lot of complaints for constituents and also, indeed, advice from their legal advisers that the addition of this and unforeseen expenditure is illegal. It's not in the legislation, Minister. When you read over it, there's no basis, I think, for adding, in an administrative way, for adding that condition to exceptional needs payment. One example I think I encountered was, which has been given to me on a number of occasions, is where, say, a grandmother had a fatal illness. When the issue of funeral expenses then arose following the grandmother's death, it stated that, of course, this may have been an exceptional expense for the family, but it's not unforeseen. It wasn't necessarily unforeseen. So the test in the 2005 legislation is that the payment may be made if exceptional circumstances arise, and it appears that the Department of Social Protection, you're erecting a further hurdle to make it more difficult to secure an exceptional needs payment. And I think, as I said, the Department's interpretation of the matter, is basically it's illegal. And if you look at the situation in relation to definitions, I know the statutory test here in the 2001 Act is exceptional, Minister. It's the in inverted commas. And I'm informed that to seek to add the statutory test at this further hurdle of unforeseen, it's unlawful. Hogan J, for example, gives an excellent explanation of the meaning of the word exceptional in the case of Mackey versus MCE versus Residential Institutions Redress Board 2016, IECA 17. In that case, and from that decision, it's clear that exceptional means, and I quote, exceptional circumstances simpliciter with the standard of exceptionally measured by reference to contemporary standards prevailing within the general public. So to bring up this additional thing, this additional standard of being unforeseen, it clearly seems to me to be illegal and to be unlawful. And I note, for example, that a number of legal advisers of constituents, that there have been a number of legal actions pursued in relation to this definition, and I think it's very notable that those cases, I think, have been settled before, in actual fact, the matter goes to court. And the reason they're being settled by the Department is that you don't have a leg to stand on, Minister, in legal terms, that you should amend the Act and accept this in front of us. So it does seem to be a situation where there's a gross anomaly which has arisen. I think it's arisen, obviously, through the implementation of austerity from 2008, when you crushed the social protection budget and tried to keep it under, at all costs, keep it under 19 billion or whatever. And exceptional needs was the area, in fact, that was most vulnerable, and in which you made, in fact, effectively the biggest savings. I noticed that the scheme, of course, itself, one of the big problems about it is that you don't keep records, Minister, of people who have actually applied. I know you gave me very detailed information, I think, on 2017, maybe earlier this year, which showed, I think it's around 9,000 applications that were successful, but you don't, I think, keep the records of the people who haven't been successful, who have been turned down because of this additional administrative law, if you like, that this House hasn't sanctioned, that's that's the way. And I mean, I'm informed, as I said, of the around 100,000 successful applications for ENPs per year. It's impossible to know how many eligible applicants are being refused due to what is clearly an improper test being applied. And as I said, you're continuing to apply that test. Your officials are, and I know clearly the powers of deciding officers in the section I'm referring to of the Consolidation Act of 2005 in section 201. But I think you have made law on the hoof, Minister, or your predecessor did, in relation to the austerity, and it's wrong, and you should just accept the amendment. Thanks, Ceann, or Cathaoirleach.
Obviously don't know how influential you are, because we actually changed it last January off the foot of us having this very conversation this time last year. You're right insofar as, and I won't keep up anybody's time, it was never in the law. It was never intended to be in the law. So I'm going to ask you to consider not pressing the amendment on the basis of, because it was never in the law, it should have never been put into the guidelines. But for some reason, and you can blame whoever you like, but it certainly wasn't me, it was put into the guidelines, but I took it out last January. And so I would very much be heartened or disheartened if you're able to tell me that there are still people being refused ENPs on the basis of unforeseen since January, because I specifically changed the guidelines last January and it's nowhere to be found anymore. Exceptional needs payments are there for exceptional needs. If you could see them coming, then they may not be exceptional, you know what I mean? But either way, the reason we're here is that as the last bastion of a source of income for people is because if they need our help, they need our help. You know, you don't choose to have an exceptional need, but it was never in the legislation, so therefore it was never a condition, but it was put in the guidelines, but I took it out last January, so it shouldn't be happening this year.
Well, I mean, the problem is that and my own legal advice is, even fairly recently, is that it continues to happen. And as I said, a number of cases had to be pursued, through a legal channel. No, this is in 2018. This has been happening, and my correspondence in relation to this is just last month.
Well, actually, as I said, I'm not going to. If you want to press it, I'm not going to object to it. I don't have a problem.
Well, I think I value the advice I get in relation to this, and for people who work so hard, for our most vulnerable people in Deputy Penrose's profession who work so hard for our most vulnerable citizens. So I thank you for doing that, Minister, and for changing that. But I would like it to be in the law so that nobody again can contravene it. So unfortunately, I do have to press it.
No, that's why you don't have to accept it. It's no problem.
So you're going to accept it?
Yep.
Okay, and it'll be in the Act. Okay, great stuff. Thanks, Cathaoirleach.
Thanks, Phil.
Great stuff.